But I'm going to go very quickly and give you some hints on how to deal with objectors in all of your cases. I'm secondly going to talk about getting certified for just the liability portion of a case. Most people know about class actions. You file a class actions for all purchasers of these defective masks, right? What most people don't know is many Supreme Courts, like in Florida, we have the Engle case with the tobacco. You could move to certify just the liability portion, and you leave the damages and the rest of it to the end. It's never used. I have no idea. There's not a lot of law review articles written on it. Since Engle, there's only been 2 cases. Mine has been one of them. And it's an amazing way to get class actions and mass actions certified. I mean, really, it's an ingenious way to do it. And I'll explain why. And it's very relevant. Even today, I am also lead counsel in the Surfside collapse case in my hometown of Miami. And think about it. You had 98 deaths in this building, and then you had about 100 apartments that all collapsed. So you have economic loss people, and you have personal injury people, okay? Just like in BP, just like in all of these big cases, you had 2 different groups of people, okay? They start out fighting each other because there's going to be a limited fund of money. And if they start fighting each other, us plaintiffs lose right off the bat because the defendants are loving it. So we have to get along together, the economic loss people and the personal injury people, so that we could focus on the defendants, go after them, make a big pot, and then, like what Ken Feinberg did, figure out how to divide it, okay? And you can do that certifying the class for liability purposes only. So we could have one trial against, say, the neighbor across the street that we may make allegations that their construction led to our collapse, and you would just have a trial, did their construction actually cause our collapse? Forget the plaintiffs. And that's just one trial. And that's amazing, because in the 70s and in the 80s, the drug companies could kill the plaintiffs because each plaintiff had to prove that smoking was defective, was defective, was addictive, was all the terrible problems before Engle, and you can't afford it. If you're a sole practitioner, if you're a single lawyer, you're not going to take on the tobacco industry. So what Engle does is it lets everybody in the country in a class action go up against the one defendant for liability purposes, and it evens the playing ground. So I'm going to talk a little bit about that. And then finally, one of the best rulings of my career was this year, mainly because of public justice. And we have Paul Bland here, who's the head of public justice, and they're like the secret superheroes for plaintiff lawyers. If you really need a heavyweight litigator, the best writers in the country to come into a controversial case, especially when it comes on appeal, and maybe that's not your forte, is doing appeals in the federal court, you can get public justice to join your case. They actually became co-counsel with us, taking the same risk that we did with amazing people. Leslie from their firm, you know, top of her class, top of the law school, but a genius on these issues. Paul is one of the best experts in the country on arbitration clauses. So he goes around the whole country and tries to fight the defendants on arbitration clauses. They also were doing that when we told them about ascertainability. There was 12 decisions in Florida that said you can't certify a class because of ascertainability. What that means is you can't easily identify all the class members, so we're not even going to let you file a class action. That is ridiculous. That was not in Rule 23. It was never contemplated. It was a horrible decision by our 11th Circuit. It was an unreported decision called Carhu, and it said when you decide the factors of Rule 23, you also have to say to the plaintiff, can you show me now that you're going to find all the class members? It's ridiculous. It's nowhere in Rule 23. So what defendants were doing is saying, we don't have any records. We can't find the people who we sold the products to, so it's not manageable, so you shouldn't certify it. And 12 cases took this ridiculous Carhu decision and kept ruling for it. So coincidentally, I had a case which had great facts, because that's what you're always looking for when you go up on appeal. We had great facts. My partner, Howie Bushman, is in the audience. He was helping run the case, and our facts were very unique. And this is where I called Paul at one of the seminars here in Vegas. I said, Paul, we have a case where we're suing Dometic. It's a company that makes refrigerators for RVs. okay? And it's defective. It's old technology. It's gas absorption technologies. And these things blow up. They literally blow up. There's about 1,000 of them that just explode every year, and there's personal injury actions for that. We brought a class action to say, give people back the actual money that they suffered, and put warnings, injunctive relief. Tell people there's a risk here, you got to be careful. The defendant said there's nothing wrong with that product, although we've changed it 6 times, because obviously something was wrong. And we can't find all of the people because RVs are sold to different people. You know, it's from the dealer to a buyer and then maybe to a rebuyer. So you can't find everybody for sure, so you shouldn't certify it, right? What was problematic for them is they did 2 national recalls that they were required to do by NHTSA, and there they certified to the federal government, oh, we found everybody. It wasn't a big deal. We could find them. You know, we could check the motor vehicle records. There's actually a database for sales of RVs. Not a problem at all. So I said to Paul, this is how we make law. We find the great facts. For arbitration, you want to have somebody who bought a CD at Best Buy, and on the back of the receipt, it says, you must arbitrate the claim. You know, the better the facts, the better the case will make. So I thought this is a case that we could use Paul's expertise, because we could change the 11th Circuit standard, and it'll change the standard all across the country for ascertainability. They did an amazing brief. We had oral argument, and the first question from the judge is to the defense counsel, you can't be serious, which was amazing. I mean, it was the best oral argument we've ever heard. And they just said, you're not even, you know, you lose all credibility with me because of the recall, but where does ascertainability come up in Rule 23? Where's that word? It's not even in it. So that can't be the reason we have ascertainability. It's really the fox guarding the hen house. It's like the defendant saying, we can't find everybody, so don't let them have any right, right? It's like, it's on its head. So we were grateful to have Paul. We reversed them. We've changed the standard forever, and now courts around the country are saying ascertainability will rarely ever be a factor to not certify a class. So those are 3 things I want to go through with you today. But on the objectors, I'm going to start with a little history. How many of you have dealt with objectors before? Okay, about half of you. So a very good trial lawyer, and I don't do personal injury law, I just do class action work, but a very good personal injury lawyer, they will tell you the first thing they do when they get a new case is to read the jury instructions, right? They start at the end, because they know when they get to the trial, what are the elements they're going to have to prove. Those are the great personal injury lawyers that I know. Most people don't do that. So with class actions, it should be the same. You should say to yourself, okay, I have a class action. I know what the Rule 23 requires. Numerosity, typicality, adequacy, predominance, that's easy. But say I have an objector. Okay, let's talk worst case scenario. One of these flyers I saw from one of these vendors said 52% of the cases have objectors. I think that's a little overstated, but they're going to probably come into your case, right? They may even come in as professional objectors, which I'll get to. So they're very knowledgeable. They know what the law is. So I always start a class action and then start the settlement process thinking they're coming in and they're going to object to me and they're going to question everything I do. So how can I beat them in drafting the settlement agreements? How can I beat them in presenting the settlement? And I'm going to show you some examples that you can actually do to be prepared for them. One of my greatest accomplishments with Howie this year is we defeated Ted Frank. He is somebody that works for an organization that is against class actions. If you go on their website, it says, we are not in favor of class actions. So he says, I'm not gaining money, but he's gaining his personal goal, which is defeat class actions. Okay, so to give you a little history, objectors are class members that say, we don't think the settlement is fair. On its face, that's incredibly helpful, right? Because when the defendant and the plaintiff reach a settlement, and then they go to the judge, there's nobody questioning them, right? So in my class at University of Miami Law School, I bring in all these settlements all the time, and I show how terrible they are. You know, just as many bad defense lawyers, there's bad plaintiff class action lawyers that do terrible settlements. I really believe that. Because once they get arm in arm, some of these plaintiff lawyers, they lose the, should we say, you know, ethics, or they lose the enthusiasm to make sure that the class is going to get everything they need, right? So do they care that the font is 10 point in a claims letter? That's ridiculous. Do they care that you have to say under penalty of perjury if that's not really necessary? No. Do they care that they're putting stuff on there for 25 pages knowing nobody will read it? No. And then their attorney's fees. Do they care if they get 33% when they don't deserve it in the jurisdiction? No. So objectors do serve a valid purpose. Okay, so starting out in the 60s and the 70s, the 80s, objectors serve a good purpose. There was a little cottage industry of professional objectors that actually made money from it. So I settle a class action with 300,000 class members, everybody who bought a mask, right? It's not hard for you to go find a class member if they just bought a mask. So just like I would send out my notice to everybody about the settlement, they'll advertise on the internet, did you buy one of the masks? You should hire me because I'm going to make sure that you're protected. It's all a guise to hire that corrupt person so that they could blackmail me and then say, okay, Adam, you want to settle your $1 billion settlement? I want $100,000 or I'm going to object to your settlement. So what do? I either pay him or I let him object, and then if he appeals, I may wait 10 years to see a penny of my money. But worse, my clients, which in many cases is an elderly group, will not see a penny for 10 years because this blackmailer is holding me up. And that was a problem for many, many years. So Judge Dow, who's on the Rules Committee, and a lot of great federal judges met. They revised the rules. They revised Rule 23 a year and a half ago. And now if I pay off those objectors, it has to be presented to the court and approved by the court. So their logic was, if you have to disclose it to the court, maybe a blackmailer is going to feel a little bit uneasy about demanding the money. Pretty good logic. I mean, I don't take the extreme position that some class action lawyers do. I would pay these people off because I think for the class to get their money today for $5,000, I hold my nose and I would do it. Because the judicial system was set up in a way where it's going to take me 10 years unless I pay the guy $5,000. So why not pay the guy $5,000? Some people say it's just immoral. I want to get the cases settled. So there's certain procedures that courts had. The first was to post a bond. They said to these objectors, you're going to hold people up for 10 years, you have to post a bond. Well, that went in the, I don't say a bad word, but it's nothing. They'd say now you have to pay costs of like $1,000. So what was originally a good idea about posting a bond, which is going to cover all of the delay, no judge in the country was enforcing any big bonds. So bonds are out. Then they revised this law, so now you have to disclose it to the court. That helps. So I'm going to show you some other really creative ways that you can get them. So this was a case we recently had, and this is the Ted Frank case. I knew he was coming in because whenever you have coupon settlements now, those are very controversial, right? What is a coupon? What's not a coupon? And the law that was revised, Rule 23, says what a coupon is and what is not a coupon, okay? So when we settled with Spartan Race, I knew this. We all knew what the law is. And in this case, somebody from the Vegas conference 2 years ago came up to me and said, I think I got a class action for you. I had a personal injury case. Somebody got hurt at the Spartan Race. And when I saw what the insurance was, it cost 50 cents to cover the racer, right? But if you go to the registration page, it says $13 race insurance fee. That sounds like one of these for-profit pass-through cases. Why are you charging me $13 for insurance if it's costing you 50 cents, unless it includes something else? So we filed the class action, and our argument was this is just a plain profit. They argued there's other things that we're including in the $13, blah, 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 but we settled because our goal was to resolve the issue. Make it more prominent that you're charging this amount. Let the customer decide if they want to pay it or not, or if they want to maybe use one of the other competing companies. But Spartan, because of COVID, had lost a lot of money, and they didn't have cash. So how are we going to settle the case? So we had to be creative. One thing they did is they created this great new app called the Spartan app, which was really great. They let us go onto it and review it, and it had great content, and people were using the Peloton and the Apple app. So it's something that would be actual value to a plaintiff. I mean, I wouldn't do it if not. This is something that was a real service to them. But we also know the law on coupons. So what we tried to do is we tried to make sure that all of the relief could not define this as a coupon. So it gave you automatic enrollment. And these are the tiny little things, if you know, you can defeat the objectors when they come in. It's not a question like we have to fill out a claim form and ask for the app. You get it automatically. You're automatically enrolled. So you don't have to take action. The reason that courts don't like coupons is you have to go do something to use it. And most people won't do that thing. Or so you certainly don't want to go back to a store. Like there was a sharper image class action. People hated sharper image. So you don't want to go back to the store. So here we had a class of people, and we did a survey, that loved Spartan. They didn't hate Spartan. It wasn't a defective product case. It was just a hidden charge case. So they're going to keep going back to Spartan, and we made them give these automatic enrollments, which had a value of $40 a month in the market, the real market. So you're giving these people something that's worth hundreds of dollars where they only, at best, lost $13. So you got to be creative when you try to do a settlement. How can I help you as the defendant, and how can I help the plaintiffs? You got to always think outside the box. We don't have cases that last 10 years because we need to really be creative, sit down with the defendant, and figure out a way to get it resolved. We saw that there would be these objections, so we did that way. We also said if you don't want the app, you can get a free membership from Spartan. Why did we do that? We saw that there was case law that as long as you're giving an option to people, that again makes it not a coupon because you're giving them a straight gift certificate that they can use. And we actually showed that there's products on the Spartan app that you could buy for under $10. So we put all this together and we retained an expert. Now, why am I paying $20,000, $30,000 for an expert? Because I think Ted Frank is coming to get me. So it's worth it to spend the $20,000 now, get a great forensic accountant who did a 20-page declaration saying, I don't think these are coupons. Now, he's not the judge. He can't make a legal conclusion, but I know they're marketable. I know that they're transferable. I know that the people don't have to do anything for them. I've reviewed the website. I've compared it to Peloton. I think it has great value. The market says it has great value because it's being charged and paid a certain rate. So he did all this. And I knew that they can't compete with something like that. So we had it filed, and he then came in, and he tried to do what we did. He had his associate go on the website and try to make some of the arguments that our expert did. And we ripped them apart. He didn't know what he was doing, his associate, and he's not a forensic accountant. So the court actually struck that part of his objection, saying that required expert testimony. So it's a chess game. We planned it out before, and we beat him so bad that this is the one case I've ever known that Ted Frank did not appeal his objection that's overruled. And this was his case of the month. This was his example to show people, see how horrible class actions are? They're giving away crappy coupons. They're horrible. Well, Mr. Frank, you're wrong. You're a sleazebag. And these are good settlements, and everybody was happy. And the results were in the proof was that we didn't have a single objector in the country of every person that called us. So you are not going to dictate, Mr. Frank, whether the settlement is good or not. The class is going to dictate it. And that's why notice always needs to go out. Remember, it's a two-step process. You settle a case preliminarily. The judge has to find that it falls within the range of reasonableness, so then notice could go out. You have to get past that bar. That bar should not be high because you really want to hear from the class members what their reaction is. We have a case now, well, I won't mention the case, but it's been 9 months since we reached a settlement, and the court hasn't decided if it reaches preliminary approval. So that means it's not even, it has to be within the reasonable grounds to be a settlement, right? Half the courts are throwing out these cases in the case I'm talking about. And this judge hasn't found that it at least falls within the range of reasonableness. To me, how is that logical? I mean, there's a very good chance we're going to lose the case on the merits. Courts are throwing out these claims as a matter of law. So that's that part. And there's no bond. And the cypre is a little controversial. It's a great avenue, and you should do it, and you should do it even for public justice. If you have money that shouldn't go back to the defendant, because you don't want them to benefit from it, and it can't go to the class members, because how are you going to give it to them if they don't claim it? Where does it go? So cypre is a French word saying to give to charity, And most courts appreciate that, and they'll approve it. The only problem is the last few years, again, some bad plaintiff lawyers get a little greedy with the cypre, and they say, oh, I want it to go to my alma mater, right? And then a judge is like, you're an idiot. I'm not giving it to your alma mater. I mean, what the, for a case where LASIK's eye injury, I want to send it to my school. Well, how's that relevant? The cypre should really relate a little bit to the claims you're bringing, so it does justice to society. That's why I think public justice would always be upheld by a court. This is another case that we had. So this is very interesting because this same judge, he's a magistrate, probably the best magistrate in the country. I really mean that. Jonathan Goodman is a magistrate in the Southern District of Florida who we have agreed to serve as the district judge in many, many of our cases. He is one of the best judges in the country. His opinions are 70, 80 pages long, and we've lost before him as well. So I'm not saying it just because he's ruled for us. But he is an amazingly intense, technical judge. So here, there was a product called Prevagen. And I'm sure if you watch Wheel of Fortune or even the Super Bowl, they have these commercials that Prevagen's going to make your memory better. I don't know if many of you have seen those commercials. So I did the case because early on, they were saying on their website that it's going to help Alzheimer's disease. Okay? So we now have our own law firm. I left my firm 3 years ago. We just focus on a few class actions that make a real difference in the world. We can fund them. We could take on anybody. And it's got to be something that also hits us personally. My mom died of Alzheimer's disease. My grandmother died. And my uncle died. So when I saw that these guys were putting on their website, this bullshit whale stuff somehow goes from your stomach and cures Alzheimer's, that put it over for me. They're going to be closed down. So I sued them. And then they started to make the changes. They took that off their website, and we started to talk with them. And, it's not our job. We're not the FTC. We're not the FDA. It's not my job to make the product off the market. My job is to let the consumers know the truth. So as part of the settlement, they had to explain to the consumers exactly what their research was. They couldn't go ahead with these fraudulent or deceptive commercials. Also, we got back money for people. So if you didn't think that the product worked for you, we got back about a half of all the money that you ever spent on the product. It was a wonderful, great settlement. So we had some objectors come in, and one objector was a little kooky guy who now we've become friends with him. But he came in and he said, I bought the product and I want to object. So the first thing that we started to do is now you have to prove that you're a class member. And nobody was really focusing on this in the past, because people just file objections. This guy, I don't believe, ever bought the product, which is pretty silly because it's only $5. But he never bought the product. So we said, show us your receipts. He couldn't. Where did you buy it? Oh, some Chinese apothecary in San Francisco. We don't believe you. So what the law says, and I think I have it up here, is that the burden is on the objector to prove that he's part of the class, not us. That's a pretty good thing. So if he can't prove he has standing, he's out. Okay? Why is that so crucial? Because if I can get his objection struck, he can't go to the appellate court and hold me up for 10 years. You see, that's my key. I could overrule him in a minute. In my sleep, I could overrule him. I don't want to overrule him. I want to crush him so he can't go to the 11th Circuit for 10 years. The way I do that is I strike him. So if he doesn't have standing, he's struck. That's the law in the land. So this is a great thing to know, because I'll tell you, I've seen a lot more cases, especially in antitrust cases, where people say they bought the product. They didn't buy the product. So that's one way. Second is when you do your settlement papers, why not require the objector to do a lot? For some reason, 80% of the settlement agreements I read doesn't say anything. It says if you want to object within 30 days. Why? Put a lot of burdens on them. Make sure that they put their phone numbers. Make sure that they give a sworn statement. Make sure they tell you all their grounds. Make sure they give you documents. Make sure they sign it. Make sure they give you statements of where they bought it. I mean, we put that as well. Proof of purchase. Put all that in there. If these guys are going to mess with your class, fight them really early on. And here they objected. Here he struck their objection. And we were able to resolve it with him, because I also try to reach out to people. I'm going to be doing class actions for 25 more years. This is all I do. I'm going to see the guy again. So I actually called him on the phone and I said, could you please, we've crushed you already. The judge has sanctioned you. You're a little nuts. You're taking a lot of medication. Let's just be friends. And I said, what if I let you come to my class action class and you could talk on objectors? I'm going to debate you and crush you, but I'll give you an audience where you could come in and say your piece. He said, great, I'd love to. So he withdrew his objection right about the same time the court struck it, which was great. I've had 3 friends since then who've called me to say, hey, can you call this guy up and try to get him to drop it? And he has. Sometimes you just got to reach out to these people. Again, it's a long-term project. Why is it important, too? There's another case that the Levin firm is in now that's before Judge Goodman for another mindfulness product, Nariva. So it's a similar product. It helps mindfulness. And they're dealing with the same issue. And we're trying to work together because we do a lot with the Levin firm. We have, for example, class actions against 23 schools in the state of Florida solely for the amount that they charge students for costs for services during COVID that they never provided. It just infuriated me. They charged over $23 million to students for like bus fees, lab fees, when the labs were closed. So some states like Georgia immediately credited those students. So what we did is we sued the Florida Department of Education and the Florida Board of Bar Governors that govern all 46 schools in Florida. And we said, we don't even want fees. Don't pay me fees. Just credit the students back this money. You took it from them. $4,000 means a lot to a college student. Let's kind of do the right thing. And what did they say? Go to hell. After 3 months, they said, go to hell. In fact, we're going to move for Rule 11 sanctions against you because we never collected any of the money, so you're suing the wrong person. I said, all right, we'll go bring the 23 class actions against all your schools. So we have the Levin firm, that's a wonderful firm, being our co-counsel, and we have Morgan & Morgan because there's a venue provision where I have to go sue them in their home jurisdiction. So I got to go to 23 cities, Polk County, and everywhere around Florida. Morgan & Morgan has an office in every city. So it was great. So it's a great team. The first case, we won. The court said, there's no sovereign immunity if you have a contract with somebody. That's just idiotic. That's like saying to Apple, you sold us 1,000 computers, and now we don't have to pay you to the school. Why is it any different to a student? So it sounds to me like it was logical, and we won. What do they try to do? And this is another example of people thinking outside the box. They try to go to the legislature, to Governor DeSantis, and pass a bill 2 months ago that would say retroactively you can't sue schools for anything that relate to COVID. Can you believe that? They actually went to lobbyists. So what did? We went to Tallahassee. We met with lobbyists, and we humiliated them. And we asked them, are you going to pass a bill? Because this is public now. Are you going to pass a bill that's going to retroactively tell a student who paid $23 million that they can't sue? Why? I mean, what's the justification for it? So the senator said, no, we would never do it. We would never do it. So they did pass a bill saying if you have personal injury claims during COVID, you can't sue the schools. That's the best argument they have against us now. They're saying that statute applies to our case. Baffling, but hopefully we'll win that. As we know with class actions, Congress is trying to pass a bill, and they will again in 2024 possibly, to ban class actions. And they want to enforce arbitration agreements that also have a class action waiver. We have to fight them. That's something that public justice does all the time. We have to battle them. I mean, I'll give you a great example of why we battle them. We did a case called forced place insurance. If you own an apartment or a house, you have to have insurance. If you don't, they can force it on you. They call it lender place insurance. Very nice term. They lend you the insurance. We claim it's forced placed. And 10 years ago, it was about 12 times the cost from what you were paying. But it gets worse. It gets worse. The bank lets the insurance company into your account, and they withdraw the money from your escrow, so the next month you're going to be foreclosed. Hundreds of thousands of people in the country were foreclosed because their escrow account was too low because the scum fraudsters took the money out without even you knowing about it. So what we did is we methodically tried to attack this. There's something called the file rate doctrine. So if you have a file rate, even if it includes a bribe or a kickback, that may preclude you from challenging it. Because our great state regulators supposedly review these rates before when they get filed, they review them. No, they don't. They just stamp them. In Florida, it was stamped in 1972. So we started against a surplus line insurer that doesn't file rates. That's how we started slowly. And then we expanded it, and we settled against 32 nationwide banks for $5.2 billion on behalf of millions of homeowners. And I'm really proud of that. Why were we able to do it? What's the sole reason? Because the Dodd-Frank Act, passed 15 years ago, says you can't put an arbitration clause in a mortgage. That's it. We don't want arbitration clauses in mortgages, and every mortgage is the same in the country. Fannie Mae, Freddie Mac have the same mortgage. So you can't put an arbitration clause. So they couldn't require me in my 32 nationwide cases to go to arbitration. So I won $5 billion, okay? Last year, Wells Fargo was accused and was proven to have put fraudulent charges on their customers' bank accounts. They just went in and said, you have a $100 charge, $400 charge, all fake, all fraudulent, right? Bunch of class actions filed. Guess what? When you have a bank account, you sign an arbitration agreement. It has to go to arbitration, and the arbitration agreement has a class action waiver. None of those people were able to sue Wells Fargo as a result. So that's how crucial these arbitration clauses can be. The final thing is this FP&L case that we had, and we were contacted because we do class action work. All these businesses in Broward County for 2 days were without water because the contractor, admittedly, screwed up. They were digging by the airport, and they hit the main water line in Fort Lauderdale. So the water was cut for 2 days, okay? The reason it's so important is because there was no water, the fire sprinklers didn't work. So the fire people would go around and have to close offices. It's not that you didn't have water, it's that you had to be closed. And with hotels, Fort Lauderdale is a very big tourist industry. With hotels, they have codes that say, if the fire sprinklers don't work, we have to evacuate the hotel immediately. So you have a lot of hotels in Fort Lauderdale that lost hundreds of thousands of dollars because they were closed for 2 days. So this is how we thought, well, how are we going to do this? Because they're going to point to some companies who maybe didn't have damages, right? Say you're a realtor office and you didn't use water. They may try to point to those examples, and this is stuff we thought of before we filed. So what we did is we looked back at the BP Oil case that we were involved in. BP Oil has the greatest language, greatest law. Fifth Circuit law from BP is also awesome. And what BP says is, once you have an injury, you have standing. So the fact that water was cut to your business means you have standing to sue, okay? Doesn't mean you have damages. So damage calculations could be done later, but at least we proved that everyone within this certain geographic region didn't get water. Pretty simple. So they fought us. They moved to dismiss. We beat that. We got the class certified. They appealed that. We got the 4th District Court of Appeal in Florida to per curiam affirm it. It's the second case in the country after Engle on these certified liability cases, and that's what's giving us a lot of confidence in the Surfside case. And in all other mass disasters, like the New Orleans Hard Rock case, like the guy who shot in Las Vegas. They're all going down the same path of trying to prove liability first. So we settled with all of those defendants yesterday, except one. And FP&L, Florida Power and Light, to their credit, they wanted to settle from day one. I mean, I want to say this. I give them a lot of credit. They want to do right by their customers, but there was one subcontractor that for whatever nefarious reason, he didn't want to settle. Whether it's because he just wanted to get the attorney's fees from his insurance company, because we made offers that were, you could imagine, lower than the insurance. He would not settle. So we settled with the other 3. We have a liability trial starting in December against that one, and we're just going to kill him. You know, and he's just crazy. You know, he discloses people who he may not, I don't want to say the guy's name, but who he may not even have retained. So we're going to battle the guy, but we're going to have a liability trial in December against that one defendant. And I think we're going to be able to prove they're 100% liable because they entered the wrong ticket to the regulated authorities when they go dig in a utility. You have to call this 811 number all across the country, say, hey, is there any lines underground? We're going to dig here. They gave the wrong address, and they wrote no boring, so you'd never think they were going to do the drilling. We think that's, as a matter of law, precludes them from even blaming the city. But they want to take a chance, so we're going to go for it. This is the new standard, and you should really know this because it's amazing. It's great language, and the best part of it, it says, administrative feasibility alone will rarely, if ever, be dispositive, but its significance will depend on the facts of each case. So that has changed class actions around the country. Many state and federal decisions have cited the Dometic case, and that's at least one rabbit hole that was killing class actions, which we've saved. So that's my presentation. I'm happy to take any questions for you. Anything you have, any comments, questions?
Goodman's a good judge.
I'm sorry? Goodman's a great judge. Oh, your neighbor? Oh, good. He's a great guy, really is. And again, he's in the file rate doctrine, he entered a 90-page order, which he was right, saying the file rate doctrine does apply. But when you go before him, you feel like you've got justice, which is the good thing. And this is going to be interesting. Now, in the Neurontin case, I know that there's some issues there where they said they weren't going to go after him. And one part I left out of this, which is important, is there's a word in there that says you have to be an aggrieved objector, an aggrieved class member to object. So I argue, if you go out and buy the product for the purpose of objecting, you're not a, quote, aggrieved objector. You're a bad faith person. So in their case, and I don't know the details, he said I don't need to reach that point at this stage because that's been withdrawn. I'll get to the merits of the objection next. But that's something to remember. I think if somebody buys the product, there's a good argument to your judge. Do not let them have standing. Because remember, you got to kill them at the district level, because if it's just overruled, you're going to wait 10 years in some of these cases to get a ruling.